The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
The case this afternoon is 2019-60787. Kevlin Dannery Espinal-Lagos et al. Versus Merrick Garland. Mr. Patel.
Thank you, Your Honor. May it please the court. My name is Vinesh Patel. I represent the petitioners. The board abused its discretion in this case by denying the motion to reopen. It abused its discretion by failing to follow its own clear, unambiguous regulation. That regulation requires that a motion contain new material evidence that was not previously available and could not have been presented or discovered. The movements or the petitioners in this case did exactly that. In the motion, they included material new evidence in the form of proof that a U visa petition had been filed for their benefit. Now, instead of
soon after it was filed, did she give it to the BIA?
I apologize, Your Honor. Could you please repeat that? I think I was talking.
How soon after the U visa and derivative U visa supplements were actually filed did she then notify BIA of it?
I think it was about, so the U visa petitions were filed about 4 months after the IJ concluded the proceedings. Yep. The motion to remand was filed about a year later. I believe when the appeal was still pending or prior to or within the 90-day period that you get to file.
I'm just asking, the petition is signed and sworn to sometime in July. The interpreter signs it, her husband signs it, July. And how soon did she then notify BIA that they had requested this?
It was approximately 1 year later. But Your Honor, it was still well within the filing period for a motion to reopen. Even after the board dismisses appeal, you're statutorily entitled to get 90 days within which to file a motion to reopen. But if the appeal is still pending, it's considered a motion to remand. Now, in this case, the board did not actually apply the regulation to ask simply whether the proof of filing was material or previously unavailable. Instead, if you look at the board's decision, it simply asks, well, could eligibility have been discussed? But the fact that something can be discussed does not make evidence available when it otherwise isn't. And so I want to break the argument down into two parts, Your Honor. One is that the evidence did meet the regulatory standard, contrary to what the board said. The evidence was new and material. The way we know it's new is because a petition wasn't filed for the benefit of the derivatives until 4 months after the former hearing. So it was not available. But it also has to be material under the regulation. The way we know that the proof of filing is material evidence is by looking at this circuit's case law and the agency's case law governing motions to continue a case. In Ramachandani versus Gonzalez, where this circuit court was considering whether a denial of a continuance was an abuse of discretion, where the petitioner was seeking a continuance to pursue a marriage-based green card, this circuit said it wasn't an abuse of discretion because no visa petition had been filed. If you look at the other agency decisions, even the one cited in the government's brief, matter of Mayan, even the agency said there that the visa petition, even in itself, is not necessarily sufficient for a continuance, almost presenting it as a bare minimum. So there's no question that the proof of filing, which was not in the power of the petitioners in this case, it had to be done by the principal, but that proof of filing was a critical triggering event to establish the derivatives eligibility. Yes, Your Honor.
And under the CFRs, that's the filing date or granting, either one will confirm eligibility. 2414 or 2014.
Yes, I believe you're referring to 8 CFR 214.14.
Yes.
It states that in order to be eligible, there has to be a petition filed by the principal for the derivative. And again, the board just asked, well, could it have been discussed based on the existence of a law enforcement certification? But the law enforcement certification is just a small piece of the puzzle. If you look at 214.14, you'll see that even the principal himself, who obtained the certification 1 week or 1.5 weeks before the final hearing, all he had was a U visa certification. But he also had to have a waiver of inadmissibility to file. He also needed proof of substantial physical and mental abuse. So the certification doesn't get you very far, even if you're the principal. Now,
But
in this
Mr.
case,
Patel, on the order itself, it says that it could have been discussed. It didn't say that discussing it would have been enough. It just says it could have been discussed. And that's a true statement, isn't it? The steps being taken could have been discussed had the lawyers communicated with one another.
well, I think that the key proviso there is that had the prior lawyer for the petitioners known that the husband, the principal, was pursuing it. But again, Your Honor, I don't believe that I do think that the board in their decision, if you look at the reason for denial, they say the regulatory requirements were not met. And so they're referring to the regulation that asks whether it's new material evidence that was not previously available. So they're hanging their hat on that regulation. Now, the board actually miscites the regulation and cites it as 1003.2C4, which doesn't exist. I think they're actually talking about C1. But the point is that this is what the board made as its basis for the denial. But that's
not irrational. The fact that it may not be what they do other times, they're not required to remand just because there's a U visa request. Isn't that discretionary? U visa is a discretionary relief.
I
right?
I agree with that, Your Honor. But this circuit court has said that if there's some sort of clear departure, an unexplained departure.
But it isn't unexplained. They say that you didn't even bring this up. Not you personally. I'm not just casting. But that not only was it not, the eligibility wasn't determined. I mean, but it wasn't even mentioned during the relevant time period. And so that's not irrational. I mean, the question, it's not whether it's wrong as a matter of law, it's whether it's irrational.
Well, I do believe that in the circuit court's decision in Barrientos, where they lay out a standard for abuse of discretion, legally erroneous interpretations of regulation or clear unexplained departures from regulation do constitute an abuse of discretion. And so in those cases, if there's a question of law, Your Honor, our position is that's still reviewed de novo by this court. And if their decision is based on an error of law, that would constitute an automatic abuse of discretion. But I would also
It says that in our circuit, because we have a whole bunch of cases that say it has to not just be wrong, it has to be irrational. So where are you getting that?
Your Honor, I was looking at the case in Barrientos, Cantarero v. Holder. It says the BIA abuses discretion when it issues a decision as capricious, irrational, utterly without foundation of the evidence, based on legally erroneous interpretations of statutes or regulations, or based on unexplained departures from regulations. Now, you made a good point, Your Honor, when you said that, well, is it really unexplained? But it's very difficult to say from the board decision. The way that it reads, at least to me, Your Honor, is that they believe they're applying the regulation. They state that this motion, even though they demonstrated prima facie eligibility, doesn't satisfy the regulatory requirements. So in the board's own view, they're trying to apply that regulation, but the problem is they don't. And that was the second point that I was going to make, which is that instead of asking, is there material evidence that was not previously available, they say, well, could it have been discussed? But you also made a good point, Your Honor, that, well, couldn't it have been discussed? But from our standpoint, there was nothing to discuss. There was no eligibility at that point.
But it would have been worth bringing up and saying, hey, you need to wait. Can you please, you could have asked to postpone. You could have said, we're working on this process and we'd like some more time.
Sure, Your Honor.
There would have been a good reason to bring it up, actually.
Well, when you say sure, counsel, how could it have been helpful at all? Because the IJ would just say, well, you're not eligible. So what the IJ couldn't have granted continuance based on having gotten an attorney. So why do you say, yes, it would have been good to bring up? If they bring it up, they lose. They won't get a continuance because they've taken a step or two.
I would agree with that, Your Honor. And if you look at the intervening decision, as the government called it in its brief, it brings up a case matter of my end, which is sort of in this long line of agency decisions governing when to grant a continuance. It says that even if you have a properly filed completed application, a filed visa petition, that alone may not be enough. So I agree with that, Your Honor.
It's not whether you would have gotten a continuance for the U visa. That's not the question. It's whether or not you could have gotten a continuance so that the lawyers could talk and figure out what was going on. Those continuances are given sometimes where they're trying to deal with the lawyer's communication issues.
That's possible, but at the time, Your Honor, I was only representing the principal, and our office was not informed that the derivatives were in proceedings at that time, and the attorney for the derivatives, who are now the petitioners, had no idea that the principal was pursuing a U visa certification. So,
do you concede that that there's no due process right or any sort of right in this relief, correct?
I do believe that. I don't concede that, Your Honor, but I also don't view that as the primary issue.
Why don't you concede that if under like Gomez Palacios and other cases like that?
Well, I do think that I do believe that it impinges on their right to a fundamentally fair hearing, where on one hand,
but there is no due process right in something that you only have an executive discretionary relief. There's no fundamental right to a U visa.
It's a statutory right, but procedurally, I do think that the petitioners are put into a bind by the agencies. On one hand, the agency is saying, you can't really get more time for this. You have nothing filed. You're not eligible. But at the same time, the agency is now saying, well, now it's too late. Now you can't move to reopen the case.
Did DHS oppose the remand?
I don't believe that DHS responded to it. So there was no opposition to the remand.
And when you keep saying the board, was this a case where the BIA was a single judge?
It was a single judge, Your Honor. It was not a panel.
And that single judge can't make any fact finding itself because the IJ has never even looked at this. So it's just, we're notifying you, single judge BIA, that actually we've now filed. And all they want to do is get back down to say, IJ, would that be enough to get a continuance? Is that what they're asking for?
Yes, that's correct, Your Honor. And on the point of the board is not only not allowed to make fact findings in the first instance, it declares that it can actually grant continuances, which it can't do either. It's only the immigration judge that could grant a continuance. But there is case law, and I believe it's cited in the opening brief, that suggests that in the context of a motion to reopen, the decision maker should not be prejudging the facts. They have to take some things, if they're inherently plausible or not inherently unbelievable, they should be taken as true.
Right, but when we're talking, the question seemed to talk about continuances. I know we had talked about continuances, about why it wasn't requested when they were actually before the proceeding. But what they've been asked to do, what it's been asked to do is a remand, not a continuance.
Well, if you, in the opening brief, and actually in the motion itself, we do request a remand for the purpose of seeking a continuance.
Right, but it's a remand that is now the issue.
That's correct. It is now the issue. You're correct.
And we have the narrowest form of review for that. It's the same as a reopen.
That's correct. It is an abuse of discretion, but Your Honor, if they clearly depart from the regulations without a satisfactory explanation, that is an abuse of discretion.
Why
And
isn't it
here-
a satisfactory explanation to say you can still pursue your U visa? You can pursue it as through a stay, and you can also pursue it later on if you are removed, or whatever the proper term would be. You can correct me on that. Why isn't that enough? The fact that you can still, they're not saying you can't pursue the U visa. They're saying that you need to use one of these other methods because we're not going to remand. Or we're not going to grant a continuance.
With respect, Your Honor, I don't believe that is an explanation for a departure. Again, I think that the way that the BIA decision is written, they're not viewing this as a departure. They're viewing this as a failure to meet the regulation itself. And with that, I think I'm out of time here, so I'll reserve the remainder of the time for rebuttal for my co-counsel. Thank you.
Okay, thank you.
Please,
Go ahead.
may it please the court, Your Honors, Joanna Watson on behalf of Respondent, the United States Attorney General. And if you look at the timeline of this case, I mean, this information could have been discovered or presented to the immigration judge prior to the entering the immigration judge's decision. I mean, this U visa, their eligibility, this whole thing had been percolating for years. In the crime that happened.
I'm just going to ask you, what is the government's bright line rule? When was Miss Espinal-Lagos eligible for U visa? That's a simple question. When was she eligible?
Eligible when it's filed. I mean, of course,
Okay, so that's the end of it, isn't it?
Well, it still could have been presented. The certification.
Well, you can't use the word it. I ask you, when was she eligible? You say when filed. That's after the IJ had the case. So how could she have said to him, I'm eligible, if she hadn't yet become eligible?
Because the certification was in place and they had enough information that they could have presented to the immigration judge.
I know they could have presented. So is the government's rule, have you thought through this nationwide, that you are eligible, hence you must present when you get an attorney? That can't be it. So is it when the district attorney signs the I-918? The government's position is whenever an alien gets the DA to sign, even though the rest of the form hasn't been filled out, the interpreter hasn't done it, there's been nothing sworn, they're eligible, so they must give it to the IJ. Is that the government's position?
When the certification was received, that's a key document. So that
I'm not asking if it's the key document. Is it the government's position? Extract from this case, whenever a district attorney signs one little portion of the application, it is the government's position that at that moment, they've got to tell the IJ they're eligible?
In this instance, they should have. It was lack of.
I know that's what the BIA said. You should have, could have. But what's the legal rule? Doesn't the CFR reg 214.14 say there are two legal dates? It's when you petition and file or when it's granted. There's no earlier when you filled out page 1 of the form, page 3 of the form.
But we're looking at motion to reopen and a discretionary motion to reopen.
But you agree it is an abuse of her discretion. It is an irrational order. If the BIA goes ahead and gives an interpretation of the reg that is contrary to the reg, at that point it would be irrational, correct?
I mean, it would depend on the situation. In this situation,
well, this situation, if the reg says you're eligible when it's been filed, and the BIA appeared to say, it said exactly, I'll read it out loud to you, you know it. She met the regulatory requirements, that is the respondent's use of easy eligibility, and the steps taken in pursuit could have been discussed. So is the government's rule of law, whenever some early steps have been made, an alien has to present it or they've lost it?
I'm not going to make a bright line in every case. Like, I can't sit here and say in every case what's going to be the situation.
Okay, let me ask it differently. Is it true that the 8th Circuit and other circuits have said if you ask to remand and you don't give us the one that's been filed, we're going to deny the remand on that basis, because you've got to have a completed sworn to application. If you give us something earlier, you lose. The Ceballos 8th Circuit case, isn't that what they held?
In this particular case,
I'm asking you to tell me what the 8th Circuit said in that case, if you're familiar with it. It's in the briefs, Caballero Marinez. They denied the motion to remand. Why? Because the applicant had not yet filed it. So it can't be both ways. You deny the remand because you haven't filed, but you deny it because you intend to file.
There's not a bright line for even granting a continuance for the immigration judge. He could have granted a continuance even in this scenario because they had that document.
But he wasn't given a chance. But he wasn't given a chance.
The immigration judge wasn't given a chance to do that.
Because the BIA said no.
No.
But I'm saying if they had presented this information, I mean, he had gone in 2016, sought Mr. Patel as counsel. I mean, if this information had been discussed, they could have presented to the immigration judge, and that's what the board's saying. That they could have.
Well, let's imagine they had. So what are you saying? As soon as they got an attorney, they should have said to the IJ, I might be eligible because I've actually gotten an attorney. That can't be it. The IJ would laugh him out of court. So then it's, I've gotten an attorney and I got a DA to sign. The IJ is going to say, okay, well, you might be eligible then. They're going to say, wait till you can swear to anything is true, right?
They had the certification and they could have presented that information. I mean,
so is the issue not whether or when the person would actually become entitled to the relief? The issue is whether or not they could discretionarily consider the steps.
In this instance, yes, it could have been raised to the immigration judge, and he could have continued, possibly.
And the fact that they could also not consider it, so you could have a situation where there is no bright line rule, that it's discretionary. That the judge can, if the judge could have granted a continuance or not, and the good judge could say, and then if they had presented it and they said, no, we're not going to give you any relief because it's too early, then they would be able to make the argument now. So they're not out of luck. It's just a discretionary call as to how the court manages it, the IJ manages it.
Absolutely. The motion to reopen standards are completely discretionary, and so the continuance is discretionary as well.
So you don't need a bright line rule in every case of how you handle the situation. You look at the facts on that case.
Correct. And the board has authority. Even if you show prima facie eligibility for relief, they can still deny in the exercise of discretion your motion.
So if you would have shown that, if they'd have had the eligibility documents, they could still deny?
They could have. They have discretion, even if you're prima facie eligible to. They could have denied the motion. And the biggest thing here too is this is collateral relief, and whether if the court decided that this should be remanded back to the immigration judge, thing is whether that happens or not, they can still go forward with this relief. They have all alternative methods. The regulations provide for a stay of removal that they can seek through DHS.
They may, but we've got to look at what's in front of us. And the BIA says she was eligible and she hadn't disclosed the steps in that regard. I think I heard you say when I asked you at the beginning, when was she eligible? She was not eligible at the time of the IJ. She only becomes eligible when she files. As a matter of law, the CFR regs, is that still correct? Eligibility isn't until you file.
It was potential relief, and the information has to be discoverable.
I think I'm just asking you the same question you did answer at the beginning. When is any alien, eligible for U visa? The earliest they can be eligible for U visa is when they file, correct?
You would have to file. Without filing, then you wouldn't become eligible. But that's not a motion to reopen. The motion to reopen,
right? But if the BIA denies the motion to remand on the ground that she was eligible, that's a legal error.
No, because the information was discussed. It could have been presented and discovered, the eligibility for it. I mean, she's still, this was, this.
Okay, we may be talking past each other. I won't push it. You keep saying it. It could have been discussed, but you're also agreeing she wasn't eligible, so she couldn't have said, I'm eligible. She could only have said, we got an attorney and the DA has signed. I sure hope that ends up in me being able to file and swearing to the truth of everything. But Your Honor, I'm not yet eligible.
Her potential eligibility was discoverable and could have been presented.
I agree with that.
The potential eligibility, and that potential eligibility could have resulted in the immigration judge, had he heard it in the first instance, possibly continuing the proceedings and possibly not. When the board says it could have been discovered, it could have been presented, eligibility, they're not incorrect. And I want to briefly say, Petitioner's Counsel was talking about 103.2C4, that the board was incorrect in the regulation. Well, the regulations changed in January of this year. I believe it's this year. And at that time, 103.2C4 existed, and that regulation says that if you file a motion to reopen while an appeal is pending, it's a motion to remand, but a motion to remand is considered under the same as a motion to reopen. Those factors of prima facie eligibility, and you have to present discoverable. You have to show that it wasn't previously available or discoverable, or you couldn't have presented it. So the board was not incorrect when they cited the reg for a motion to remand and how it's considered. And going back to that,
So an alien, just so if the Fifth Circuit's going to announce the rule of law you're urging is, you have to raise before an IJ potential eligibility. And potential eligibility could be you've begun to fill out the form.
Again, this is discretionary, and the board has discretion and the immigration judge has discretion. And because it's discretionary, there isn't a bright line. But in this instance, the board was not incorrect when they said you could have shown your potential eligibility for this. The fact that your attorneys failed to communicate, petitioner failed to communicate with her attorney about her husband's relief, and he's in a derivative on her asylum application. I mean, the board in this case, they have.
But in the ruling itself, it doesn't say respondent's potential U visa eligibility. It says respondent's U visa eligibility. And I keep trying to focus on, I don't see any supporting law for that. She wasn't eligible. She couldn't have told the IJ I'm eligible. She had taken some steps towards it. I think we agree.
She could have shown that her husband had the certification and then he was applying for this relief, and she could have got derivative status. It was a possible relief that she could have been. Do
you have any cases? They may exist. I'm just asking this because this is your area, where we have IJ or BIA determinations that having gotten an attorney would get you a continuance because you might be eligible. Can you think of any case where a continuance has been granted at the IJ level because you got an attorney, but you're not yet swearing to the truth of anything? Can you think of any case?
I cannot at the moment, but I can do a little research and I'd be happy to do it.
My guess is like that Eighth Circuit case, you lose really quickly. You'll never get your continuance because you haven't even told the government you want the U visa. You're just promising a judge that you may one day ask for one. I don't see how they'd ever grant you a continuance on that. Maybe there's a case that shows they do.
And there's lots of unpublished cases that we're only seeing a small portion of what happens with the board.
Well, it's a question I'm asking. If it's not in the briefs, you're certainly welcome to 28J with any case ever where an IJ has granted a continuance because an alien says, one day we hope we'll file an IJ. We're beginning to pull it together.
Counsel,
But again, I just want to, I apologize.
Go ahead and answer Judge Higginson's question.
No, I was just going to say again that we're not talking about a continuance here. We're talking about the motion to reopen, and we're talking about the regulatory language on a motion to reopen that talks about it. You have to show that you couldn't discover it and you couldn't present it. And I keep going back to that because it's not about the continuance. It's about whether they could have discovered and presented it. I mean, that's ultimately what they wanted.
my reading of the record, I'm just telling you, it is that you were eligible. And this alien would have lied if the alien had said, I'm eligible. I'm not yet.
Potential eligibility. And I can't think of right now, but potential eligibility, I'm sure comes up all the time. You're married to a US citizen but haven't filed your I-130, the petitions haven't been filed yet, but that's a possibility. And you presented that to the immigration judge. And it didn't, you actually presented it. You're married to this person, and maybe
that would be very helpful, because I agree. If the language of their CFR were to say potential eligibility is what decides it, yes. You haven't been able to tell me a case. And my larger worry is the whole U visa regime, as I understand it, is helping the government. This doesn't help aliens. It helps us prosecute crimes. I don't think they get protection against removability when the cooperation's over. So the whole structure is trying to keep people who will be witnesses. Is that right as an overview?
Yeah, that's why these are in place, but there's also stays that are in place that you can apply with DHS. You can apply for a stay while it's pending. And
did DHS oppose the motion to remand?
I do not believe they did. They didn't file anything.
Because they would want to help the DA get the witness. They don't want the alien gone, but the result of this is alien goes that could help maybe against crime.
Well, it's actually the husband is the one that applied. We're talking about the derivatives. I mean, he's the person that's eligible. Petitioners and the sons are not the ones that reported that, were witnesses to the crime or anything. We're talking derivative status here, which I mean, there's a bit of a, they're not the lead applicants for this.
Could I ask a question, please? I am wondering, assuming arguendo that the BIA order is incorrect, and that it's not talking about potential, but it's actually talking about actual eligibility, and that it's incorrect because she's not eligible. Does that mean you lose? And if not, why not? It's a different way of asking things that Judge Higginson was asking you multiple times. Do you lose if the BIA order is incorrect with regard to eligibility? Or can you still win under the discretionary standard that we use?
I believe the discretionary standard that you would, and they're just, the board didn't require showing the eligibility of the filing. They're just talking about the steps that were taken. You didn't discuss the steps that were taken in order for potential eligibility for this relief.
For my question, I want you to assume arguendo that the order contains an error in it, and that it's about eligibility. Assume arguendo that the order is incorrect about when she was eligible or if she were eligible at the time that this BIA review took place. Can you still win even if they're incorrect? Do they have to be correct? Do they have to be correct in order for you to win, or can you win anyway because it's for whatever reason?
I mean, if you're saying like there was a factual error in how the board interpreted the evidence of eligibility.
Right. We're saying here that assuming arguendo that the respondent doesn't have U-verse eligibility, and that's a reason that was given, that they already had that, can you still win?
If they were eligible for it, would it still win that they didn't? I mean, they have discretion to deny even if they're prima facie eligible. So yes, I mean,
So you can deny the motion to reopen or the motion even if you show prima facie. Regardless even of whether you're right or wrong about eligibility.
Well, no, in that, I mean, if there's an error there, that would be an issue if they didn't address the evidence properly and in their discretion. But I don't see how in this particular case they didn't. She just says that you didn't discuss it. You could have raised this. It was discoverable. It was presentable information. And she's talking about, again, the eligibility.
Now, if
the steps taken in pursuit.
If the alien prevails here, she doesn't even get the continuance. It just means the IJ gets to think of all of these issues, right? The application in full sworn to is given to the IJ and then practically unreviewable as far as I can tell. So it's just acknowledging that she filed pretty much as soon as she could. She couldn't have done anything before other than talk about steps.
Well, she could have not waited a year to file the motion to reopen.
I agree. That's a good point. But I would be curious if that were as a separate basis. I could see maybe the BIA had said, listen, by the time you did file, because my view is focused on the regs. And maybe that is a separate basis. That hasn't been argued yet. But that was a long time to wait before telling the BIA, I fully agree with you. To me, that's actually a stronger argument, but I don't know if there's law supporting that.
I mean, they don't speak to that in this, so I wouldn't say, but so I'll just end with, they didn't present this information and they could have. I mean, they obviously couldn't have presented the final filed, but they could have presented the possibility of this relief. And that's what the board's saying. It's the possibility. That they're not saying you had to show, the whole filing. It's just the possibility of this could have been raised because that's what the reg says. You have to show that it wasn't discoverable and you couldn't have presented it. And
thank you, Ms. Watson. We have your argument. Thank you.
Thank you.
Mr. Alvillar.
Good afternoon, Your Honors. May it please the court, my name is Francisco Alvillar, co-counsel for petitioners. The government's position that the BIA acted within its discretion is wrong for 3 reasons. First and foremost, the government mischaracterizes the issue. In its brief, it states the question is whether our clients could have presented evidence of U visa eligibility prior to the immigration judge's decision. But this statement fails to address a significant argument advanced in our filings to the board and to this court. Specifically, quoting our brief to the BIA, quote, respondents contend that the evidence of the July 6, 2018 filing of the U visa applications post-dating the individual hearing is material and was not available and could not have been discovered or presented at the former hearing. The same argument was made in our opening brief. But the government, and likewise the BIA, omitted any reference to the issue of whether the July 2018 proof of filing supported reopening. The omission of the argument matters because, as this court put in Adele Masai, BINS, the Fifth Circuit reviews a BIA's decision procedurally to ensure that the complaining alien has received full and fair consideration of all circumstances giving rise to his or her claims. And since the government, and by extension the agency, did not give full and fair consideration to all our circumstances supporting our claims, it's appropriate to remand the case for a proper review.
Now, wait, just quickly on that.
Yes,
You're saying in the brief, they said the issue is, did she disclose eligibility? But now an oral argument is, did she disclose possible or potential eligibility? That's a changed position. But
no,
what if the government's right that the CFR require any alien to say, even as little as I got a lawyer, that's in theory, potential eligibility?
Yeah, Your Honor, I believe, yes, sir. So we're actually arguing both, that because of the circumstances, considering that it could not have been discovered, but we're also arguing that the filing, proof of filing, the eligibility, as you put it, is new evidence that is material and did not exist prior to the final hearing. So in sense, we're not shifting gears in the arguments, but we're just advancing the second one, that the proof of filing matters. But I'd agree with the position that eligibility, that's a really high standard to just go into court and just suggest that I could sometime in the future potentially file for a U visa.
Let's okay. Mr. Patel, you may complete the rebuttal then. Thank you.
Sure. We spent some time talking about the fact that she's not eligible, as the government concedes, until a visa petition is filed for her. I just want to clarify 2 points. One is that, just so everyone's clear, she cannot file for herself. She has no agency. The lead petitioner in this case has no agency, no power. She depends on the principal to file a petition for her, and that is called a supplement A, which is either filed at the same time as the principal petition or after. The second and final point I want to make is that we're approaching it from the same mistaken framework, I think, that the board approached it with which is this could have been discussed standard. Again, I would urge the court to consider that could have been discussed is not the standard in the regulation. The regulation is asking us to look at the motion and ask whether it contains material new evidence. That's it. That's the regulation that the board hung its hat on. Does it contain material evidence that was previously unavailable? And I don't think there's any dispute as to the fact that the proof of filing was not available at the time of the former hearing. It was not available because it didn't exist, and that's because the principal had not filed the petition. And was it material? Absolutely. She couldn't have gotten a continuance without having the visa petition filed. So I want to.
Mr. Patel, could I ask a question? We were talking earlier in the argument about whether or not it was futile. We have an alternative bases in our circuit that the court sometimes even raises sua sponte, that even if they didn't follow, that it's futile to reopen. And would it be futile here where there was a year gap?
You're asking, would it be futile to reopen the case?
Right. And if it's futile to reopen, then we don't find, even if there's error, we don't grant relief sometimes.
No, I absolutely believe that it is not futile, Your Honor. If you look at some of the agency decisions governing a continuance, they're going to ask, well, is she prima facie eligible? And the case on point is matter of Sanchez Sosa, which governs motions to continue a case in the U visa context. And they've said that ordinarily there is a presumption in favor of granting a continuance when you have a filed visa petition and you've demonstrated prima facie eligibility. So I do strongly believe that if this is remanded to the immigration judge would grant a continuance. And this is sort of outside the record, but I have several cases pending before the immigration court in Dallas in the same procedural posture.
Okay, I don't want to go outside the record.
Sure, but to answer it briefly, no, absolutely, I do not believe it would be futile if the circuit court reopened or ordered the BIA to remand the case.
Can I ask one question?
Certainly.
Yes, Your Honor.
It may be adverse to your position, but it's the same question because Ms. Watson brought it up. Are you aware of any IJ decision where the IJ has continued on the basis of potential or possible eligibility because, say, an attorney had been engaged or the DA had said, I want you, or signed something? Are you aware of any IJ ever granting a continuance because of an early step like that?
Not in any sort of published or even unpublished decision. But it is feasible, to be perfectly frank, that an immigration judge could say, sure, we'll give you some more time. That's perfectly feasible. But, Your Honor, this never have I seen that happen at a late stage in the proceedings, 1.5 weeks before the final hearing. In my experience, an immigration judge would tell you to get out of there and just rule on the asylum case. So it does matter quite a bit, the stage of proceedings. I would also mention that in the last few years, the Board of Immigration Appeals has tightened the screws on granting motions to continue. And you can see that in the case that's cited in the government's brief, Mayan, where now they're saying, well, even if you have a visa petition, even if you are eligible, it doesn't necessarily mean that a continuance has to be granted. So I think it just goes to show that
wonderful thing or not. And so if there's any time to make any argument, I understand. If there's not, the court's very busy. So we can continue if Mr. Patel can.
Well, I mean, the time was, Mr. Patel, you're back.
Okay, great. Yeah. I just
whoever it is, I guess we've already had two riders on this horse. You may have, 30 seconds to wrap it up, because we got to wrap it up. So
Your Honor, let me just say this. The government mentions the question of eligibility. That proof of filing means something, and that's not just our position. That's the position taken by the board in matter of Sanchez Sosa. They have said that the prima facie showing in the filing of that U visa ordinary warrants a continuance. And so
we have that.
Okay.
Thank you. We have your argument.
Thank you,
We
Judge.
did the best we could with the technology.
Oh, yes.
And we appreciate the arguments that we heard today. Thank you. The case is submitted.